Hi everybody, welcome back to Law Hero. I'm so happy to be back. I missed it so much. I think it was like 2 weeks for me without Law Hero and I was like, I need my drug. So today we're going to talk about property law, FE1, and we're going to use the March 2019 paper as our guinea pig. Some high level on the exam, like a high level summary of what I think is my assessment of the exam overall. So I've said it's like normally an even mix of questions. In the context of a problem question, the ability to apply the law to the facts is rewarded with high marks. And we've seen this time and time again. And then of course it's the extreme opposite in the essay question, because there you can be a total gen and you can go off on a tangent, and it can, as long as it's a relevant tangent, you can give your opinion on the law. I mean, that's what an academic is. There's somebody who sits back and they're like, wait a second, I have an opinion on this. So, yeah. What else? Timing is crucial. I mean, in every FE1 exam, timing is crucial. I go through that in how to pass the FE1's videos, which I'll link below. The thing is, you need to tell the client up front what the legal position is in the introduction rather than as an afterthought. Amen, sister. And the other things you can do, which Dr. Aisling Parks likes, is to highlight case law or the sections of the legislation. Okay, so the first question relates to finding or treasure trove. And this is normally a problem question. Someone's walking along, they find something which is perhaps disjointed in the soil, has become loose. Fact of the matter is, if it's gold, silver, or a bullion, which is gold or other precious metal and is an artefact, it belongs to the state, and this was established in Webb v Ireland, which is the Derry-na-Flan hoard, and that can be seen in Dublin in the museum, National Museum of Ireland. So yeah, if it's not any of those things, then it's just simply an object. Obviously the person who owns the object has best title to it. If you find it, it's not finders keepers, you have second best title to it, and the person who actually owns the land where the thing was dropped, they don't have any title to it. But obviously if 1 and 2 are gone, they'll get it by default. So question 2 was a lovely question on co-owning property, and part A was a nod to comorientes, which is a fancy word for when everyone dies at the same time. As in, you cannot ascertain the time of death, and if they jointly own property together, that means that last person standing principle doesn't apply. So that's when a joint tenancy converts into a tenancy in common, and you have to split the assets according to the number of people who died, and here it was 2. They died in a helicopter. And then part B then is about Tom and Jerry, who are dentists, and they put equal amounts into a dentist practice. Now things are gone sour. One of them wants to pull out, and now one of them is sick, and they want to know, can they pass on their property to their loved ones. So this is obviously a joint tenancy, and which has the right of survivorship, as in last person standing gets all the stuff. There's ways to sever a joint tenancy. So there's like alienation, which is one person sells their share and that severs the joint tenancy and creates a tenancy in common. Or if they all alienated, and then purchase or rent monies, and that's what's happening here. That's another way to sever the joint tenancy and turn into a tenancy in common. Question 3 is an essay on succession law, and it's actually a quote from Kenny J in FMV TAM, which is a very important piece of case law because it goes into the definition of proper provision. Question 4 is also an essay question, and it's about family law, and it says, describe the situations where conveyance by a spouse or civil partner. So they want you to bear in mind the 2010 Act, Cohabitation and Civil Partnership Act, of an interest in the family or shared home, Family Home 1976 Act, Shared Home 2010 Act, will be valid despite the absence of prior written consent. Prior written consent by the non-transferring spouse or civil partner comes under section 3, which is alienation of the family or shared home. By the other spouse or civil partner, your answer should be supported by relevant legal authorities. There are certain times when you actually don't need the consent of your spouse or your civil partner. The court may, subject to the provisions of the section, dispense with the consent. I'm going so slow, I'm only on question 5. Question 5 is actually a very straightforward little problem question on how to enforce security, which is given under a mortgage. So I have a whole chapter on the mortgage and how to enforce it. Mortgage deed, and nowadays they're quite standardized, especially from the big banks. They will, if they're pre-2009, they will reference the 1881 Conveyancing Act, and that has power of sale, powers of receiver, insure the property, go into possession, all of those things. But they are, if it's pre-2009, it'll be all that. But if it's post-2009, those are statutory rights. They're bulked up much more in 2009 Act, which you are allowed to bring into the exam with you. That's why I think mortgages is a really good question, because you have the Act there with you. And if you get very, very familiar with the mortgages section, which is like, I think it's like section 99, section 100, section 101. If you get very, very comfortable with that, that could be a really handy question, because you have the law. Question 6 is an essay question on, does the law of adverse possession need to be reformed? And I mean, that is a highly opinionated question. And, I think the best approach is you either say yes or no and then say why. I think a lot of people will say yes, and the reason is because, we are a bit behind in Ireland when it comes to adverse possession, when it comes to other countries. You could certainly do a bit of reading around that, and I'll definitely throw in a little bit in my notes about that. But we have some conflicting, confusing guidance from the court, like stuff like, he looked across the ditch, and that is him asserting his possession. It's just so woolly. Question 7 is a juicy problem question where you have somebody who's dying, her boyfriend is a solicitor, he forced her to write the will, there's some issues with witnesses, did they see it, did they not, validity of the will, the executor, testamentary freedom, all that stuff, capacity, section 77, Section 78, formal requirements to make a will. What happens if you amend your will? What happens if, the will is burnt? All this stuff. And then the last question was the one I told y'all to ignore, because I just don't find value in writing about rights of residence. So, I'm burnt out from this video. I love property law so much. I hope you enjoyed that video. Please give me a like and a subscribe, because I really want to grow this channel, because I think, I'm only going to get better. Like, these are my first few videos, and speaking to yourself in your room and talking about property law and law, which is my passion, and I just can't help it. I love it so much, and I just really hope I can somehow help you and inspire you to just keep going with your legal battle, and you're going to make it someday. You're going to be a solicitor, and if I can do it, anyone can do it. Okay, have a lovely day. Bye bye.